Hello, I'm Helen Jago, a Departmental Director at Palmer Solicitors based in our Rayleigh office. Want to know more about the duties of executors and other personal representatives? If so, then listen in to this under 5-minute explanatory video. So what are personal representatives? This is a generic term for the people who sort out an estate when someone passes away. If there are people appointed in a will, then they will be called executors. If there is no will or the executor appointment fails for any reason, then they will be administrators. For the purposes of this video, I will refer to the executors and administrators collectively as the PRs, which is of course short for personal representatives. What are their duties? Well, let's split this up into 3 parts. 1, the pre-grant phase, 2, the grant application phase, and 3, the post-grant phase. What happens in the pre-grant phase? Very first steps might include registering the death, making the funeral arrangements, making sure any assets are secure, and that any properties in the estate are insured. In addition, in the pre-grant phase, the PRs will need to find out the values of all the assets and liabilities in the estate, usually by notifying all the institutions of the death and requesting date of death balances. They may also need to arrange valuations of properties and household possessions. Income providers such as the DWP and pension provider companies will also need to be notified. The PR will need to investigate whether there is any will and ensure that it is the last will of the deceased. Further inquiries will need to be made about any lifetime gifts and trusts which the deceased may have been party to. Stage 2 is the grant application stage. Once the values of the estate have been determined, then it will often be necessary to apply for the grant of representation. And this is a generic name for all types of grants. The most common type of grant is perhaps best known as a grant of probate, which is when an executor appointed in a will takes out the grant. For all grant applications, an inheritance tax return is required, either a short form return of information in the simpler cases or a full inheritance tax return with supporting schedules if there is inheritance tax to pay, or the estate comprises certain assets which require a full return. At this stage, it is necessary to claim any available nil rate bands. This is essential as you don't want the estate to have to pay more tax than it needs to. As well as filling out the appropriate inheritance tax return, you will also need to sign a legal statement. This is usually now produced following a digital probate application, but in certain cases, a longer paper application is still required. The grant application is made with the appropriate fee, and at last, a few weeks later, the grant should arrive. And then we move on to the post-grant phase. At this point, the grant is sent off to all the institutions who haven't yet released the funds, and the assets are cashed in or transferred and debts are settled. Property is sold or transferred to the beneficiaries, and the final utility bills are sorted out. Once the assets have been collected in and the liabilities have all been settled, then the PRs will need to distribute the assets in accordance with the terms of the will, if there is one, or the intestacy provisions if there is no will. In all but the simplest of cases, estate accounts should be prepared, showing the monies coming in and the monies going out, and the distribution between the beneficiaries. Are there other duties? The PRs might also need to ensure income tax returns are submitted to the date of death and also for the administration period. They might want to place statutory adverts for potential unknown debts, which they might otherwise be personally liable for. And they may wish to carry out bankruptcy searches before making distributions to the beneficiaries. There may be ongoing trusts, and the PRs may turn into trustees and may need advice in this respect. Whatever type of estate you are faced with, Palmer Solicitors have an experienced team of private client solicitors across our 4 offices. We will be happy to assist you. At the current time, if you are an executor or an administrator, we also offer a free initial 45-minute meeting to go through the specific duties relevant to the estate you are dealing with in a professional, friendly, clear and sensitive way. That's all for this bite-sized explanation.